And same will be read by the President of the Court. That petition, hereinafter referred to as the petition. The petitioner, who was the presidential candidate of the National Democratic Congress, NDC, in the 7th December 2020 presidential elections, is seeking 6 reliefs against the Electoral Commission as first respondent, and the presidential candidate of the New Patriotic Party, NPP, as the second respondent. The reliefs are in the nature of 3 declarations and 3 orders. Aside of Relief Ye, which is praying the court to restrain the second respondent from holding himself out as the president-elect of Ghana, all the other reliefs were directed against the first respondent. These reliefs are: A declaration that Mrs. Jane Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential elections held on 7th December 2020, was in breach of Article 63, Clause 3 of the 1992 Constitution in the declaration she made on 9th December 2020 in respect of the presidential election that was held on 7th December 2020. B, a declaration that, based on the data contained in the declaration made by Mrs. Jane Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7th December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. C, a declaration that the purported declaration made on 9th December 2020 of the results of the presidential election by Mrs. Jane Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7th December 2020, is unconstitutional, null and void, and of no effect whatsoever. D, an order annulling the declaration of President-elect Instrument 2020 CI 135, dated 9th December 2020, issued under the hand of Mrs. Jane Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7th December 2020 and gazetted on 10th December 2020. E, an order of injunction restraining the second respondent from holding himself out as president-elect. F, an order of mandatory injunction directing the first respondent to proceed to conduct a second election with petitioner and second respondent as the candidates as required under Article 63, Clause 4 and 5 of the 1992 Constitution. The language in which the first 4 reliefs, A to D, were crafted is suggestive that they were directed against the chairperson of the first respondent. However, the petition is not against her personally, but against the first respondent as an institution of state established under the 1982 Constitution. The article and rule under which the petitioner mounted the action are Article 64(1) of the 1992 Constitution and Rule 68A of the Rules of the Supreme Court, CR 16 as amended by CR 74 and CR 99. They provide as follows: 64 Clause 1. The validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of election in respect of which the petition is presented. Rule 68A, despite Rule 45(4), the parties in the petition shall be A, the petitioner as specified in Article 64, Clause 1 of the Constitution, and B, the person declared elected as president and the Electoral Commission, who together shall be the respondents. Though the petitioner is not in substance attacking the validity of the 7th December 2020 presidential elections, but only the declaration made on the 9th of December 2020, the petition is seen by many as a rehash of the presidential election petition of 2012-2013. In that petition, the second respondent herein, then as first petitioner and others, invoke Article 64, Clause 1, purportedly to invalidate the election of the petitioner herein, then as first respondent, as president-elect, as a novelty done in the constitutional history of the Fourth Republic, and Sir JSC prefaced his judgment in that petition in the following words, quote, "The facts surrounding this suit have been fully played out in near epic dimensions before the public. However, there is no way this suit can be seen as a likeness of the numerous cases on various aspects of our 1992 Constitution. Indeed, I venture to say it cannot be compared to any of the cases touching on various aspects of our Constitution. By virtue of this peculiar nature and potential effects, many commentators have rightly described this suit as one posing a test of the structural maturity of our democratic ethos, causing all eyes worldwide to focus, even if only briefly, on our polity to see if and how we can surmount this unquiet challenge. Without doubt, the resolution of this case portends much for the future path of our democratic development. See, end of quote. See in presidential election petition, Akufo-Addo and Bawumia and Akufo-Addo, Bawumia and Obechebelamte, number 4, versus Mahama, Electoral Commission and National Democratic Congress, number 4, 2013, Supreme Court of Ghana Law Report, Special Edition, page 73 at page 151. Answer JS's description in the petition before the court in 2013 in the above words was apt, as that case remains one of the most important constitutional cases this apex court has determined in our current constitutional dispensation. It is therefore not strange that the attention that greeted the 2012 petition also gripped the instant one before us, thus placing the two seemingly similar cases on the same pedestal. The big question, however, is, are the two cases alike, or do they present similar issues for determination? The answer in both questions is a big no. It is therefore not surprising that the petitioner in his closing address filed on 23rd of February 2021 admitted the similarity in the instant petition and that of 2012-2013. Background to the petition. On the 7th December 2020, the first respondent hearing, the Electoral Commission, which is the constitutional body established under Article 43 of the Constitution 1992 to conduct all elections and referenda in Ghana, conducted parliamentary and presidential elections in all 275 constituencies in the country, which are made up of 38,622 polling stations. The election was conducted under Public Elections Regulations 2020 CI 127. At the close of the exercise, the first respondent, through its chairperson, declared the second respondent, Nana Addo Dankwa Akufo-Addo, who was the presidential candidate of the New Patriotic Party, as the one validly elected as the President of the Republic of Ghana. This declaration was made on the 9th of December 2020, subject to Article 63, Clause 9 of the Constitution 1992 and Regulations 4410 D and 11 of CI 127-2020, an instrument Declaration of President-elect Instrument 2020 CI 135 was published under the hand of the chairperson of the first respondent to that effect and published in the Gazette on 10 December 2020. The instrument reads, quote, in exercise of the power conferred on the Electoral Commission under Article 63, Clause 9 of the 1992 Constitution, this instrument is hereby made. Nana Addo Dankwa Akufo-Addo, the New Patriotic Party MPP presidential candidate, having in the presidential election held on the 7th of December 2020, pursuant to Article 63, Clause 3 of the Constitution, obtained more than 50% of the total number of valid votes cast, is hereby declared the President-elect of the Republic of Ghana. Given under my hand the 9th day of December 2020, signed Mrs. Jean Mensah, Chairperson of the Electoral Commission. End of quote.